Yes. Oh. Yes.
This is your lordship.
Yes.
Reginald Uzoit. Reginald Uzoit.
Yes.
I would humbly appear for the defendant applicant.
Very well.
Thank you, my lord.
Yes. So this is my ruling. I have carefully considered the processes filed and the submissions of the parties. I start with some preliminary matters noticeable in the written addresses of the parties. I start off with the defendant's reply on points of law, which is in the main re-argument of the submissions of the defendant earlier made, and an attempt to bring in points that the defendant omitted to make in the earlier submissions. A reply on point of law is meant to be just what it is. That is a reply on points of law. It should be limited to answering only new points arising from the opposing brief. It is not meant for the party replying on points of law to re-argue its case or bring in points it forgot to advance when it filed its written address. It is not a forum to engage in arguments at large. Alternatively put, a reply on points of law is not meant to improve on the quality of a written address. The reply brief is not a repair kit to correct or put right an error or lacuna in the initial brief of argument. See Mosier versus Mbamalu, Satumari versus Apagu, Jolubo and another versus Aino and another, Mosakoni Limited versus Aspinall. The citations are in the ruling. The effect of non-compliance is that the court will discountenance such reply briefs. See Rulogun and others versus Abolo Injo and another. The citation is in the ruling. Still on written address, Order 45, Rule 2, Sub Rule 2 and 3.1 of the court's rules enjoins that a written address shall be set out in paragraphs and numbered serially. However, a look at the claimant's written address indicates that the paragraphs are not numbered seriatim. Neither is the written address concluded with a numbered summary of the points raised and the prayers. A list of all authorities referred to are not submitted with the written address as stipulated in the rules. See Anima Shao versus the state, Oraizwe versus Igboneme, and UAC of Nigeria Limited versus Fashoiton and another. By Order 45, Rule 3, Sub 2 of the court's rules, failure to comply with Rules 2 and 3, Sub 1 of Order 45 may render the written address incompetent. I could readily visit the written address of the claimant with this sanction, but I chose not to in the interest of justice. Again, while the defendant's motion on notice was brought pursuant to Order 9, Rules 5 and 6, and Order 35, Rule 7 of the court's rules, praying that this suit be set aside on the ground stated on the motion paper. The written address was rather in support of the notice of preliminary objection. When a preliminary objection would be filed and when a motion on notice would suffice, the Apex Court stated in Umana Jr. versus NDIC, citation supplied, that, quote, the purpose of a preliminary objection is to convince the court that the appeal, for instance, comes to an end if found to be correct. Where a preliminary objection would not be the appropriate process before it, a motion on notice filed complaining about a few grounds or defects would suffice. See Lisa versus Bufo, Dakolo and two others versus Dakolo and three others, Wachuku and another versus Owunwame and another. See also Isa versus Inek and three others. The citations are in the ruling, and there is the close of quote. In paragraph 4.7 of its written address, the defendant stated thus, quote, serving of hearing notice on the appellant is a precondition to the exercise of jurisdiction of the court below, as it is basic to the invocation of jurisdiction of the court, close of quote. In this application, there is, to the best of my knowledge, no indication as to who is appellant or which court is the court below in the context of the defendant's application. In paragraph 4.12 of its written address, the defendant stated that, quote, the defendant, having obtained this judgment by means of misinforming the court, close of quote. Legal work is one that requires not only skill on the part of the practitioner, but it does require meticulous and due diligence. Learned counsel must therefore ensure that as a minister in the temple of justice, where only learned men practice, the proof of true learning must be exhibited, not only in advocacy, but indeed in the drafting of legal instruments. Drafting, being a skill that is expressed in the English language, must convey the intent and purpose not only in clear and terse language, but must show the appreciation of the English language, which is the tool of the profession, via spell check. See Magaji versus Kuyambana, Sheshe versus Ibrahim, East Chase Aluminum Products Limited versus Ugu and another, Uchenna Cyprian versus Emmanuel Uzo. The citations are in the ruling. With respect to learned senior counsel, I find it unfathomable that counsel assigned to prepare and file processes will not proofread his work before filing same in court. The factual matrix undergirding this application is quite intriguing. The first contention of the defendant is that she was not served with hearing notices of the proceeding that culminated in the judgment and the claimant's amended statement of claim. That where service is not effected or a wrong party is served in place of another, as in the instant case, the intendment of the law becomes defeated. Such failure of a condition precedent goes to the root of the matter. Cited Mark versus Eke, First Bank of Nigeria PLC versus TSA Industries Limited, and Eke versus Ubonda, Supra. The second contention of the defendant is that after the court allowed parties to settle out of court, the defendant issued the claimant a check for the said sum claimed. That claimant received and accepted the said check that when the defendant issued the claimant a letter accepting her resignation and rescinding her dismissal, the claimant's counsel eventually came to court on 4th December 2019 to misinform the court that settlement failed in the matter, that the defendant's action makes this suit liable to be set aside by this court. He cited Jeff and others versus Yotium and others Supra. In reaction, the claimant argued that there was never a proceeding held in court, including that of 4th December 2019, of which the defendant did not receive a hearing notice. The claimant's counsel did not misinform the court that settlement failed, rather that there was no final settlement between the claimant and the defendant, as the defendant refused to pay claimant's complete gratuity and to offer any amount to mitigate the damages she suffered and the cost of this suit. That the defendant, out of their own volition, while the case was pending, issued her, excuse me, issued her a manager's check number 000-8867691 of 750,000 naira only. That at paragraph 40 of her additional statement on oath, dated 3rd October 2019, and filed on 8th October 2019, claimant brought to the notice of the court the position and even pleaded and tendered the photocopy of the manager's check, which was admitted in evidence and marked Exhibit CW 13, that there was no concealment of any fact whatsoever, that the defendant applicant has not proved fraud, non-service, lack of jurisdiction, or any other reason to hold that the judgment in this suit be set aside. Cited order 36, rule 7 of the court's rules, Yakubu versus Tamboya, and 2 others, Supra. The general proposition of the law, as stated by the Court of Appeal in EcoBank Nigeria PLC versus Admira Environmental Care Limited and 2 others, is that a court has no power to set aside or vary its earlier order except in circumstances where there has been a fundamental defect in the proceedings leading up to the making of the order sought to be set aside. In this regard, a clear distinction is drawn between proceedings or orders which are nullities by reason of a fundamental defect, which goes to the jurisdiction and or competence of the court on the one hand, and those in respect of which there has been nothing worse than a mere irregularity on the other hand. In the case of the former, a person affected by such an order is entitled ex debito justitia to have the order set aside. And this could be done by the court which made the order without any need for an appeal or a higher court. See Anaguta versus Iweka 2 and Aguendu versus Owumere. The citations are in the ruling. Close of quote. The emphasis here is on the court as a single entity and not on the individual judges of the court. It seems, therefore, that in a situation of fundamental defect in the proceedings resulting in a nullity, a court or judge may set aside its order and that of another court or judge of concurrent or coordinate jurisdiction. See Obora versus Ogu and another. For instance, where a writ or application was served on the adverse party, She's Ken Consort Nigeria Limited and another versus Godwin Sunday UK, or where the action is tainted with fraud, see Leonard Okoye and others versus Nigeria Construction and Furniture Company Limited, or the court is bereft of jurisdiction to entertain the action or for any other reason, the order of a complete nullity. See Okoli, Ojiako, 7 others. Versus Ogweze and others. Lawal versus Dawodu. See also Ekerete versus Eke, Silium and others versus Mashi and others. Craig versus Coulson and Bello versus Inek. The citations are in the ruling. On the defendant's contention that she was not served with any hearing notice, the defendant cited the record of proceedings of 12th October 2020, 18th November 2020, 3rd February 2021, 7th October 2021, which shows that (083-731-9217) and 0803-032-2813. And those numbers belong to Oliver Okonkwo Esquire, the dismissed company secretary of the defendant since 13th January 2020, long before the said proceedings took place. That aside these aforesaid text messages, which were not conveyed to the defendant did not receive any form of hearing notices for the proceedings aforesaid. The law is trite that a court of law is entitled to look into its record and make use of any document it considers relevant in determining the issue before it. See Olaya versus IGP and others. See also Nuhu versus Ogele, Texaco Panama Incorporated versus Share Petroleum Development Company, and PDP and others versus Eze Onwuka and another. The citations are in the ruling. At page 50 of the judge's file in suit number NICN/OCA/37/2018, it is indicated that the general form of complaint dated 11th December 2018 and addressed to the defendant, that is Uzondo Microfinance Bank Limited, St. Mary's Catholic Parish Compound, also Eze Avenue, Oka, Anambra State, was received by Obeta Mary Jane, who endorsed or acknowledged the receipt of same on 11th December 2018. The affidavit of service of the general form of complaint on the defendant was duly deposed to by Anachunam Felix, a bailiff of the court, on 12th December 2018, as indicated at page 51 of the file. Page 52 of the judge's file shows that O.N. Okonkwo Esquire of Okonkwo, Mokwe and Partners, legal practitioners, 34 Dix Avenue, Amobia, Anambra State, with the phone numbers accompanying, filed memorandum of appearance dated 16th December 2018. He filed it on the 17th of December 2018, and counsel entered appearance for the defendant in this suit. The memorandum of appearance is addressed for service on the claimant, care of her counsel at 7 Old Cemetery Road, Onitsha, with phone number 303-310-5181. In Idigbe versus Commissioner of Police, the citation is in the ruling, the Apex Court heard per Onogen JSC as he then does. I'm quoting the Supreme Court. The word appearance is defined in Black Law Dictionary, 8th edition, page 107, as follows. A coming into court as a party or interested person, or as a lawyer on behalf of a party on interested or interested person. Especially a defendant's act of taking part in a lawsuit, whereby, whether by formally participating in it or by an answer, demurrer, or motion, or by taking post-judgment steps in the lawsuit in either the trial court or an appellate court, close of court. See also Abacha versus Scholastic Nigeria Limited, Petcave Nigeria Limited, and another versus Elder Bodu and another, Kaite versus Union Bank of Nigeria PLC. The citations are in the ruling. Furthermore, as decided in DK versus UBN, the citation is there. The purpose of filing memorandum of appearance is to let the other side know that the writ of summons had been received, but the action may be defended and the address for service of other documents be known to the other side, or the address of the solicitor who is appearing for the defendant. The Black's Law Dictionary, 10th edition, at page 154, defines attorney of record as, quote, the lawyer who appears for a party in a lawsuit and who is entitled to receive on the party's behalf all proceedings and other formal documents from the court and from other parties, close of court. It is also termed counsel of record. A web search at sites mentioned in the ruling, attorney of record variously as, quote, the attorney who has appeared in court and or signed pleadings or other forms on behalf of a client. The lawyer remains the attorney of record until some other attorney or the client substitutes for him or her. He or she is allowed by the court to withdraw or after the case is closed. In the United States of America, Federal Rules of Civil Procedure, paragraph 5B states that if a party is represented by an attorney, service of legal action in most cases must be made on the attorney unless the court orders service on the party. The case of Guam Economic Development Authority versus Uloa Court of Appeal for the Ninth Circuit, published 14th March 1998, assessed per Paul, Circuit Judge, confirmed that service of notice upon attorney of record is an adequate means of service notice on the attorney's client. In Saleh versus Abba and others, the citation is supplied. The Apex Court, per Bagge, JSC, as he then was of the emphatic opinion that since counsel to the respondents was served and he did not deny such service, there is effective and competent service. The contention that the respondents should have been served personally is misplaced. Service on the counsel, S.I. Ame, Senior Advocate of Nigeria, representative of the respondents, is good, competent, and effective enough. Any assumed irregularity is only as to form rather than substance. Any seeming irregularity does not amount by any definition to denial of notice to the respondent. Close of quote. See also Odutola versus Kayode, ICRC versus Olabode, MTN versus IRE, and others. The citations are in the ruling. From the above, I hold that the records of the court are serially reflected in the judge's file and as acknowledged by applicant's counsel in paragraph 2A of applicant's written address, clearly indicate that the defendant was duly served hearing notices at all material times in the course of trial through its attorney on record. By the law as established by the authorities copiously cited above and the court's records, the defendant was formally represented by O.N. Okonkwo Esquire of Okonkwo, Mokwe and Partners via the memorandum of appearance filed in court dated 16th December 2018. The argument of the defendant that O.N. Okonkwo Esquire was never engaged by the defendant as counsel in this matter is strictly between the defendant and counsel. It was never raised in court at any time during the pendency of trial. As the Supreme Court clearly stated in Saleh versus Abba and other supra, any seeming irregularity does not bear on our jurisdiction, close of quote, and I so hold. The defendant being represented throughout the trial by counsel does not, in my view, have any local standard to raise the issue of hearing notice for the proceedings, having been represented by counsel, and I so hold.
As the court pleases.
It is even more so when the defendant's attorney of record has not raised such issue before the court, having been duly and appropriately issued and served hearing notices throughout the course of trial. Regarding the defendant's argument that the judgment of the court was obtained by fraud and misrepresentation on the part of the claimant and her counsel, a look at the claimant's claim will indicate that claimant sought 5 reliefs. That is, A, a declaration that dismissal of the claimant by the letter of dismissal dated 14th July 2015 by the defendant is wrongful. B, an order giving effect to the letter of resignation of the claimant dated 4th May 2015. C, an order of specific performance by the defendant to pay the claimant 754,442 naira 50, 754,442 naira 50 kobo, being her gratuity. D, general damages of 10 million naira. E, cost of the suit. In paragraph 10 of its affidavit, in support of defendant applicant's motion to set aside the judgment, the defendant's managing director averred that pursuant to the efforts at settlement, the defendant issued the claimant a check dated 26 August 2019 for the sum of 750,000. Sorry, 750. Well, what is following does not amount to 750,000, but I wrote sick. When you look at it, you will see what you wrote and what is in the ruling, which is the sum claimed by the claimant as her entitled gratuity. That's Exhibit CW 13. The defendant went on in paragraph 11 that the defendant's counsel stumbled into the court midway into proceedings of 4th December 2019 and misinformed the court that settlement failed, while concealing the fact that the claimant has been paid her claimed gratuity as part of the settlement. In paragraph 12, the defendant alluded to a letter dated 14th April 2021, accepting the claimant's resignation and rescinded the claimant's dismissal, citing Exhibit C, annexed to defendant's affidavit. Also attached to Exhibit C is defendant's letter dated 13th January 2020, dismissing Barrister Oliver N. Okonkwo as a staff of the defendant retrospectively with effect from October 2019. What is pertinent to observe here is that the defendant's purported letter to the claimant is dated 14th April 2021 and on O.N. Okonkwo, attorney of record, dated 13th January 2020. What this means is that the two letters were documents made by the defendant during the pendency of this suit. The law is, however, settled that documents made or procured at a time an action is pending before a court of law by an interested party cannot be of any evidential value in the same matter that is pending. See Anagbado versus Farouk. See also Abdullahi versus Hashidu, wherein it was heard that, quote, the next issue is as to the status of Exhibit JJ and KK. There is no doubt that when these documents were made, pleadings had been filed and served. Therefore, they were made at the time of the proceedings of the case. Exhibit M2 is a document which, on its face value, appears to be the government's expression of its acquaintance of the recommendation of the Judicial Commission of Inquiry, which indicated the first respondents, Exhibit JJ and KK, which on their face seek to explain the federal government's position on M2, were obviously wrongly admitted as they were made in the course of the proceedings. Therefore, they are of no evidential value in assessing the worth of these documents, close of quote. See also Asuko versus Asuko, UTC Nigeria PLC versus Lawal, and Nigerian Social Insurance Trust versus Clifco Nigeria Limited. The citations are in the ruling. Exhibit C, dated 14th April 2021, and obviously made during the pendency of this suit, cannot be relied upon to establish a case of fraud. Same also not bearing any modicum of proof. And I so hope.
As the court pleases.
I am not persuaded that there is a fundamental defect in the proceedings resulting in a nullity, and I so hope.
As the court pleases.
The defendant's submission that the judgment of this court was obtained by fraud and misrepresentation, therefore, cannot stand.
As the court pleases.
What is required of the parties is the filing of terms of settlement duly endorsed by the parties and counsel representing them for further consideration or action by the court, not the bandying of contentious documents before the court, post-judgment, when the court is conscience official. See Dingadi and another versus INEC, and cited International Estate Limited and others versus Francis and others. On the whole, the defendant's applicant's application lacks merit. I see no reason why I should set aside the judgment of this court in suit number NICN/OCA/37/2018 between the claimant and the defendant hearing delivered on 2nd December 2021. This application fails and so is accordingly dismissed. Ruling is entered accordingly. I make no order as to cause.
As the court pleases. Yes, my lord. We are very much grateful for the considered ruling. We thank your lordship for the time taken to write this detailed ruling, and we appreciate the court. Thank you, sir.
Take your time.
What is the date? So, having come to the conclusion of the ruling, the court will rise now.
I'm grateful, my lord.
Yes.
Grateful, sir.
With this one.
Okay. It's not listed. I stopped it. I have another matter. Number 17. 17 on the top.
Mama, I no come online. Let me check. 5 participants. Good darling.
The court's not sitting anymore.
Court arrest. Good morning, sir. Who dismisses the application, but he didn't make any orders to cost. That he didn't find any merit in that. The judgment was not obtained by court.
Sorry, I'm just wondering, has the court finished sitting for the day? Sorry, I'm just wondering, has the court finished sitting for the day, or he just rose for a while? Hello, I don't know if anyone is hearing me. Is anyone hearing me?
That's woman.
Court may rise and not also can communicate, you know. Sure. Come mama on a court rise to go for the last time on all Kagana, you know. And then I've been raising my hand, nobody is responding to me. I'm not on a mute.
Why are you able to put it here now? When you couldn't put it there? What is this sound here? Okay. The court is called to order. NIC and OCA 36, 2021. Chukwuemeka Odumegu, Ojukwu University and one other versus Barrister VOS Okeke. Appearances of counsel in this matter.
May it please, Your Lordship.
Yes.
Dr. Jesse Mba.
Mba with an H or just BA?
Yes, my lord, with an H.
Yes, you're appearing for who? Jesse Mba Esquire, you are appearing for who?
The applicant in this matter, Your Lordship.
Yes. Any appearance for the respondent? VOS Okeke? Any appearance for the respondent? VOS Okeke, Barrister VOS Okeke? They not serve. Hold on. Are you sure they have notice of today's visual sitting? Is it not 10 o'clock? What is supposed to say? Ask him. Oh, is it not 10 o'clock? What time did you give him?
It's supposed to be online, 10 a.m. That's by now. It is not my WhatsApp. You link through virtual, through Zoom. Please join the meeting via Zoom.
So it's mean that I should sit and be waiting for you. What is his name? Asipurido. They are not serious. People just want to make money, but they are not serious about their work. Counsel to the applicant, are you still there? JC Mba Esquire for the applicant, are you still there? Hello?
Yes, my lord.
We're trying to link up with the with counsel to the respondent. It appears he has not linked up with the system. We're trying to see if we can hook up. Huh? What is the meaning of online? Okay. Iwuchukwu? Spell no? NW?
NWH.
Let him announce appearance.
My
Not
lord,
him.
so sorry, my lord. My lord, CI Nwiguru.
Why are you not properly dressed? Where is your
My lord,
wig?
I just rushed in. My lord, I just rushed
You
in
are
and
not
they
properly
told me
before
that-
the court. You are not
My lord,
properly
can I-
before the court. You are not supposed to stand before me and talk like that.
My lord, so sorry.
You don't have any
I was
right
just-
to appear rudely before me like that, unless you want me to
My
cite you
lord,
for contempt.
My lord, I'm sorry. My lord, I'm sorry. My
What's
lord,
the
can I pray
problem
for
with
stand
you?
down? Let me just dress up. My lord, can I pray for
Am
stand
I
down?
the
Let
one
me
that will
just do
stand
the
down and be
so
waiting
sorry.
for you? Is that how it's supposed to be?
So sorry.
You are not a serious person.
No, my lord. No, my
I give
lord.
you 1 minute. What is the problem? What kind of nonsense is that? You think you are appearing before a magistrate court? When was he served this motion paper? This should be proof of service, son.
My lord, I'm back.
Yes, call your name. I want to record your appearance.
Yes, my lord. CI Nwiguru, my lord. CI Nwiguru. NWIHURU.
Yes.
My lord, I announced my appearance for the respondents.
Yes.
Yes, my lord.
Applicants counsel, are you ready?
Yes, my lord.
Proceed.
My lord, yeah, today is for us to move our motion.
Proceed, please. Proceed.
Yes, my lord, you will recall that on the 2nd of March, when we appeared before this honorable court, that the respondent counsel was not ready for this proceeding. That the court granted adjournment to today to enable them to serve their counter affidavit.
Yes.
Or any other processes they may wish to. But until now, my lord, nothing was served. There was no communication.
Counsel to respondent, you heard that. What are you saying?
Yes, my lord. My lord, the last adjourned date, the court granted me, the respondent leave to file their counter affidavit. Yes, my lord, we did file the counter affidavit this morning. And
What do you mean by this morning?
My lord, it's this morning that I was able to file the counter affidavit. My lord, just as I told my lord, informed my lord the other time. So I was able to secure those materials and I filed it this morning.
What do you mean by secured the document? When you were briefed by Okeke, he should have furnished you with everything you needed at the date he was briefing you. You cannot say it's like fishing for materials to file your motion. What do you mean by that? And meanwhile, the motion by the applicants was served on you on the 30th of November. 30th of November, that is what our record shows. You were served the processes on the 30th of November last year.
Yes, my lord.
Last year.
Yes, my lord.
So from 30th November till today, you have been trying to gather materials from Okeke to do your case. So how do I take both of you serious?
My lord, not just from Okeke. My lord, I'm
serious. Either the respondent or you as counsel. Because from 3rd of March, from 2nd March till today, is time enough for you to do anything you would have wanted to do. Not to come today when the matter is coming up. No. You rush and file something in court.
So sorry, my lord. My lord, I did
What's the meaning of that?
So sorry,
yes,
my lord.
You did inform the court that what?
On the last day that the JIEGU, who has the case file in this matter and who prepared this, who was replying to this counter, was sick. And I told my lord that I will go to the place where he is and get a key to have access to these processes. My lord, I was all doing this, putting all this effort alone, my lord. My lord, the respondent in this case, my lord, has nothing doing. I was the one taking care of it to make sure that I appear properly.
You cannot tell me that the lawyer has nothing doing. Don't tell me that. You cannot tell me that the lawyer has nothing doing. And I'm not here for you to lean on my shoulders and start crying. That is nonsense. That is not what lawyers do. That is not what we do in court. Don't bring those kind of nonsense sentiments to me. That is nonsensical. That the respondent is out of job. A lawyer, how can you tell me that? So don't bring those kind of sentiments before me. They are nonsense before me. Don't try that.
So sorry,
don't ever try that. You think you will win me over by crying over sentimental issues? Don't give me that crap. Don't give me that crap. Whether he's in job or out of job is not my business. What I'm interested in is the diligence with which both of you, or none of it, that both of you are handling this matter. Even VOS Okeke himself. You are just raising alibis for nothing. That somebody go, whoever had the materials. He is a lawyer himself. If the lawyer that did the matter at trial has finished the matter, why wouldn't he collect his materials? Why wouldn't he collect his materials? Was the judgment delivered yesterday? That's another nonsense excuse. That's another nonsense excuse. Once Igu has finished his matter, why don't you pack your things? Why do you allow your things to be with Igu so that you come and begin to raise alibi? You think I will take you and the Okeke serious? Don't give me that. Don't give me that. You are just exposing either your nonchalance or like a daisical attitude towards everything, including your client. So don't give me that. Don't ever give me that, thinking that you will convince me. It makes me even angry if you don't know. So don't toe that line. Don't toe that line. You think you will get me by sentiments. That's nonsense. So you are saying that what you filed today has not yet been served on counsel for the applicant?
No, my lord, I posted it through her WhatsApp and email address. Through her WhatsApp.
Whatever process you did, you think she's not entitled to look at it and reply?
No, my lord, she's
still has
entitled
time
to look at it.
She's
Yes,
entitled to it. I don't know how you people approach things. I don't like that at all. I don't like that at all. The way you people are handling this thing, I don't like it. So you are saying you have not served your counter affidavit on counsel to the applicant, or you sent it electronically today? What are you saying now? Maybe he has gone off again. I don't like this kind of report things. See there?
Yes, my lord.
So you have heard what counsel to the respondent is saying now. What do we do?
Yes, my lord. My lord, this is very sad. Has had November till now. Sorry, my lord, I lost connection.
Yes.
My lord,
what were you saying? Let me hear you.
Yes, my lord. I said friends are not keen, are not very, very disadvantaged to grant them one more adjournment, considering the fact that they had all the time to do this. I want to plead with the court to not to adjourn this matter anymore. Let the court deem it that they have no counter affidavit to start. This is not the only matter with Idigbe and Co. The matters in their offices, on their office, have been going on. They have no interest in this case, my lord.
But what they are saying is that they needed to collect documents from Igu, not that Igu is doing this matter. What the lawyer is telling me that he needed to retrieve the respondents' materials or papers from Igu. That's what he's saying.
My lord, this is since November. They are trying to frustrate this application. My lord, this is since November. This matter is not a private matter. It is Igu and Co. The files of a lawyer is meant to be in his office, or at least a place accessible to other lawyers. It will be unfair to pass to give another adjournment will be a pat on the back of incompetence, my lord.
Counsel to respondent, are you still there?
Yes, my lord. My phone was down.
Have you been served? Have you been served with the motion on notice?
Yes, my lord. We have a motion on. They served us motion on notice.
When?
My lord, that was sometimes 2021, around the last year. I know it's last year, my lord. I
What
didn't
I'm
know the
saying,
exact
it
date.
was on the 30th. You don't even know the date. You are saying sometime end of year. I've told you
30th of
already.
November.
Now,
30th of November. 30th of November,
then is that what you
2021.
cannot repeat after me? I gave you the date. Now you are saying sometime end of November, end of the year. 30th November is not even end of year because we have a full month ahead.
Yes, my lord. 30th November.
Unless you are talking about the last week in December, that is when it's end of year. But November is not definitely end of year.
Yes.
So, counsel to the applicant, if you are ready and you want to proceed, fine, we will proceed.
Yes, my lord, I'm ready. I bring before you a motion on notice. But pursuant to order 64.
Wait, I have not told you to go on. So you say you are ready. What did you hear me say?
Yeah. Oh, sorry, my lord. I'm very sorry, my lord.
Just hold on for 2-3 minutes. I'll call you. I will tell you when to go on. Just hold on for 1-2 minutes.
As my lord pleases.
Yes. Proceed.
Thank you, my lord.
Yes.
My lord, before you is a motion on notice. Brought pursuant to order 64. Rule 81.
To order.
64, my lord.
Yes.
Rule 81 of the
Yes.
Industrial Court Rule 2017.
Yes.
My lord, it's a motion for stay of execution.
Yes.
Of the judgment of this honorable court.
Yes.
pending the appeal filed against the said judgment.
Yes.
And such further orders as the Honorable Court may deem fit.
Yes.
To make in these circumstances.
Yes.
My Lord, this motion is supported by 17 paragraph affidavit.
Yes.
My Lord, it is dated 23rd November 2021 and served.
Dated what?
23rd November, my Lord.
Yes.
Filed the same date.
Yes.
Served on the 30th of November 2021, my Lord.
Did you say filed the same date? I thought you said filed the same date.
Yes, my Lord.
Then
Sorry, filed on the
23rd and
30th
30th the same? But you said filed the
Sorry,
same
Your
date.
Lordship. Yes, my Lord. Yes, my Lord. Sorry, sir.
Proceed.
My Lord, it is supported by a written address.
Yes. Yes. Applicants, counsel, I'm listening to you. Your motion is supported by a written address. Proceed. Is it network or what? Wow. Hello? Hello? How do we know network is bad? It is okay, my own. Okay.
I'm very sorry, my Lord. It's connection issue.
Yes.
Yes, my
Yes,
Lord.
proceed.
We move in terms of the contents of this motion, my Lord.
Yes.
May it please your lordship.
Okay. Respondents Council. Let me hear
Yes,
you.
my lord.
Yes.
Yes, my lord. My lord, the respondents, in opposition to the motion, filed a counter affidavit of 15 paragraphs. Deposed to by the respondents on record.
Yes.
Yes, my lord.
Yes.
My lord, the counter affidavit is accompanied with a written address dated 23rd of March, 2022.
Sorry, my lord. Sorry, my lord.
Yes.
My lord, I stand to oppose the motion, the counter affidavit that my learned friend is trying to move. That document
Why?
is not
Because
before
I
the
told you, wait, listen to me. I suggested a date, you refused. You proceeded to go on. You wanted to, to go on. That is the consequence of your going on, which means it didn't bother you that he filed it today. I gave you that window of opportunity. You closed it. You cannot begin to open it now.
No, my lord, I didn't understand it that way. No,
What do you mean by
said
understand it that way? Are you the only one before me? That was the window I opened for you. You shut it in my face. You cannot eat your cake and have it. Listen to me. Listen to me. I said listen to me. You cannot eat your cake and have it. I gave you the opportunity. You refused. You cannot eat your cake and have it.
My lord, I thought you were foreclosing them. I didn't know they would be given opportunity to be heard again for a document that is not before the honorable court. My lord, I thought
it is before me. It is before me. It has been filed in court. It is before me. Am I the one that told you that it is not before me? Am I the one that gave you that information? Wait, am I the one that gave you that information that it is not before me? Where is it? What is this? What is this? I'm showing you something now. Look at the something. If you're saying it's not before me, what is this?
My lord, if
listen to me. You cannot sit there and tell me, wait. You cannot tell me what is before me and what is not before me. You cannot tell me what is before me and what is not before me. You are not sitting on this chair with me. We are not co-sitting on this chair. You cannot tell me what is before me and what is not before me. I suggested that we'll take a date. You refused. You decided to proceed. That is the consequence of proceeding. And it is my discretion. Listen to me. It is not your discretion. It is my discretion. It is my discretion. You don't share that discretion with me. If I wanted to move, if I wanted to give him a chance, I would have given him. But since you say no, you will proceed, I say fine, proceed. The discretion to adjourn or do that is waived by you. So you cannot eat your cake and have it. Simple. I have discretion, you don't have discretion. But if you decide to waive your right, you cannot go back to it. Simple. It is that very simple. And you should know that you are on the other side and I'm on this side, presiding. You cannot eat your cake and have it.
Very well.
You cannot eat your cake and have it. Bear that in mind very well. I give you opportunity, you refuse it, you proceed. Then you are turning back to shut the door in somebody's face. When you yourself have already opened it. What do you mean by that? What do you mean by that? Proceed. Dated 23rd what?
Yes, my lord, dated 23rd. My lord.
Proceed. I said proceed.
Yes, my lord, dated.
You cannot even talk. Very much. Eh?
I'm so sorry for the network interruption.
It's a network issue. It's a network issue.
Yes, ma'am.
Third March.
I have recorded you. You are the counter affidavit is before me. Just don't waste my time because of network issue. I'm ruling.
So sorry, my lord.
Yes.
So sorry, my lord. It is network failure. It's dated 23rd March. The written address dated 23rd March 2022
Yes.
and filed on the same day.
Yes.
My lord, we adopt it as our argument in urging my lord to refuse the application. We are grateful, my lord.
Okay. This is my ruling. I have carefully considered the submissions of the parties in this application. In First City Monument Bank PLC versus Tamcell Nigeria Limited and others. The citation is in the ruling. The Court of Appeal heard per Oji Abadua, JCA, thus. I am quoting the Court of Appeal now. The court's discretion to grant stay of execution must be exercised judiciously, and it would be so exercised where it is shown that the appeal involves substantial points of law necessitating the parties and issues being in status quo until the legal issues are resolved. Close of quote. I need to state that going through the applicant's processes, I have not seen any copy of the notice of appeal that the applicant filed at the Court of Appeal, aside her ipse dixit. There is no deposition in the affidavit that applicant has approached the registry of this court to compile records to transmit to the Court of Appeal. The inability of the respondent to refund the judgment sum or policy issues involved, whatever that means, cannot be ground to deny the respondent from reaping the fruits of his judgment, or weighty enough to lead to the grant of this application. In the circumstance, it is my determination that this application lacks merit. Same is accordingly struck out. I so order.
As call, please. My Lord, we are grateful for the erudite ruling. Very grateful, my Lord.
Sorry, my Lord, I thank you for this judgment, but I'll be coming for judicial review because before this honorable court, there are records that spoke up to the court of.
You don't expect me to go on a wild goose chase, do you? You think that once you come and file documents before the court, they will just be magnetically pulled into your motion paper? If whatever documents you file before this court are before the court, and you want them to be part of your motion, they should be there in your affidavit as annexures. Did you do that? You want me to go on a wild goose chase? Wait, you want me to do the work of a clerical officer? Rummaging through papers you have filed when you have not annexed them to your motion paper?
My Lord, I'm so sorry, my Lord. It's not your fault, my Lord. I'm surprised to know that it is not before the in my file here.
You have to annex it to your motion paper and the affidavit. Don't let me be angry with you. If you have filed anything in court, or anything, put it as an extra to your motion paper in terms of the affidavit in support. If you have not done that, you expect me to go on a wild goose chase. You want me to go on a wild goose chase and start rummaging through files as if I'm a clerical officer? What do you mean? How can you be talking like that? How can you be talking like that? Did you annex them to your affidavit in support of your motion? You want me to go on a wild goose chase? What kind of lawyer are you?
Yes, my Lord.
What do you mean by that? Anyway, I am rising now. I wish you were in court live. I know what I would have done to you. That is contempt in the face of the court. That is contempt in the face of the court. You expect me to do clerical work, to go and rummage through files and bring processes you have filed to consider your application when you didn't annex them to the affidavit. Nonsense. The court will rise.